All right, good morning. There was a problem with Facebook going live this morning. I don't know if the feed is slow, something on Facebook's side, but we're going to record today's update and then just post it to Facebook and LinkedIn once it's uploaded to YouTube. So I hope everyone's doing well today. It is Thursday, April 23rd, I believe, and time for today's update or today's discussion. So today I'm going to talk a little bit about New Jersey probate and what you should know when someone dies. Unfortunately, during these times, people are losing loved ones. They're not even able to be with their loved ones at their deathbed. Sometimes they have to see them through Zoom or don't even get a chance to say goodbye. So it's a very sad, difficult time where nurses and doctors are acting as surrogate relatives to, help people. People can't go to cemeteries for funerals. And it's really difficult. But I have been asked the question, and I have had to deal with the situation of probate. So I'm going to talk a little bit about today about New Jersey probate. And this doesn't apply in other states. Some states, the probate process is an arduous process and a costly process. That's not the case in New Jersey. But I am getting questions, and I am working on some probates for people to help them with things. And there are some things you can do on your own, which we're going to talk about, to save some time and money. And then there's some things where you can get an attorney involved. I'd be happy to help you with the process and then only charge you for the work that I need to do on my end. So when it comes to probate, we're talking about dealing with the assets of your loved one and retitling them and passing them on to survivors in accordance with your will or accordance with beneficiary designations or titling designations of other assets. So probate is a process where your will is filed with the surrogate's office, called the surrogate's court or surrogate's office, in a particular county in which you die. So I live in Westfield. If I died, my will would be probated in Union County in the surrogate's office in Elizabeth. New Jersey is a relatively simple process. So my executor, which would be my wife, would fax or email a copy of my will to the surrogate's office. The surrogate's office, and with some other paperwork, the surrogate's office would prepare some letters and some affidavits that my wife would need to sign in front of a notary, write a check probably for $150 to $200, and receive certificates called letters of testamentary, which now appoints her as the executor to go out and represent the estate and retitle assets, whether it's the house that we own or bank accounts, securities accounts, dealing with companies I may have worked for or so forth. Okay. And the process in New Jersey is not really a formal process. There's no formal opening of the estate in court. There's no formal closing of the estate. In certain situations where you may have an elderly parent that no longer owns their home, that's renting an apartment in an elderly community, maybe has an IRA and a joint bank account with you, you may not even have to file probate in those situations. And even in situations where your assets are being left to a spouse or all to a lineal descendant like a child, you can use certain short forms in New Jersey called, there's an L8, which you can see on the screen, which is for non-real estate investments like bank accounts and security accounts and so forth. If the person who passed away owns a business, for example, you wouldn't be able to use an L8. And an L9 applies to real estate. So if you own your home and you're seeking a waiver for the home, even if it's a jointly owned property, you would use the L9. So those are available online through the state Treasury Department. You can do a search for L8s and L9s and so forth. So that makes it a little bit even easier for surviving children or surviving parents, surviving spouses to probate the estate. So assets that may pass through probate are assets that you own individually that don't have any sort of a titling or beneficiary designation, and there's assets that pass outside of probate. Assets that pass outside the probate process will include anything that has a beneficiary designation, like a life insurance policy, an annuity, an IRA, a 401k. If you name a POD on a bank account, POD standing for pay on death, you can name a beneficiary of most accounts with a bank, and it would pass to those people directly. Also, if your house is titled or other property is titled jointly with rights to survivorship, you might see um, um, JWROS, which stands for Joint with Rights of Survivorship, that property would pass automatically by operation of law and avoid the probate process. It does not, however, necessarily avoid the tax system. We have an inheritance tax in New Jersey, which generally applies only to non-lineal descendants. So if you have property that's being left to parents, which would be lineally above you, or children or grandchildren, what are called Class A beneficiaries, the inheritance tax wouldn't apply. But sometimes you still need a tax waiver for a financial institution to release assets, or for a title company to insure a title if you're selling a house, for example, or some other piece of real estate. In those cases, you can use the L8 or the L9 if you're a lineal descendant. If not, you might have to file for a full probate. But even the full probate is not that difficult. It's more the inheritance tax waiver that's going to take time. So a skilled attorney, generally, some accountants know how to do this, would have to file an inheritance tax return with the state of New Jersey to obtain what's called an inheritance tax waiver, to show that either taxes have been paid or that they're not due. And then the property can be sold or the bank accounts can be released. Most financial institutions will release half of the account, I think up to a cap of $50,000, but you can get access to some money. But generally, you might have to file some forms to get access to some of the accounts. Okay, so when it comes to the probate process, so you go and you get appointed as executor. You now have these letters, testamentary, which allows you to represent the estate. You may have to get a tax ID number and open a new bank account and marshal assets into that bank account. You may have to deal with final income tax returns of the person that passed away. And just so you know, in New Jersey, this isn't true in all states, New Jersey has a 10-day waiting period from the date of death. So if I passed away, my spouse could not file probate in New Jersey for 10 days. That's to deal with certain things, not just grieving, but there's also a contestability period. So if somebody wants to contest the estate, wants to file what's called a caveat to block the probate of the estate, which is a form you can file if you're concerned that something's wrong and you're entitled to something and you haven't been named under the will, you can file a caveat. Then until that caveat's removed, you won't be able to file the probate. As the executor, you're going to have to notify any beneficiaries, any potential beneficiaries of the will, offer them a copy of the will, and so forth. If your spouse or significant other or your relative dies without a will, they die what's called intestate, without a will, they'll be subject to the rules of the state in which they died, where they were resident. So if they're resident of New Jersey, they die intestate, the probate process is a little bit different. It may be more formal. You may have to actually file a complaint in court. Sometimes you don't have to. Sometimes you can file some more paperwork with the surrogate's office. And unlike some other departments of the court that are normally dealing with attorneys, the surrogate's office deals with a lot of individuals, and they're very easy to work with in most of the counties. So you usually can call up, they'll talk with you. They're dealing with, grieving relatives, and they're very user-friendly, and they'll help you through the process to do as much as you can. They can't do your tax filings, but they certainly can help you get appointed. So when it comes to dying intestate, if you have a situation where, let's say you have a will that wasn't properly executed, it was drafted, maybe they did it through LegalZoom, they didn't use a lawyer, and it was never signed, or it was signed incorrectly, or wasn't properly witnessed, or something like that, you could make application to the court to accept the will as a valid will to be binding, because maybe the will says something different than what happened in the intestacy process. That you may have to file a complaint in court with the surrogate's court to appear and accept the will. You may have to get affidavits from other potential beneficiaries, whether it's siblings or children or so forth, to acknowledge that the will is the valid will and the intention of the person who was looking to draft it. So that's a little bit of advice. I know a lot of people use other services, online services, to draft their will. They think their situation's simple. But if you don't do this for a living, you can make mistakes along the way. So don't overlook the fact that, saving several $100s or $1,000 may not be worth it in the long run. I've mentioned this in the past, but for simple situations, if you're looking to do a simple will, you have what you believe is a simple situation. If you go to my website, I have automated services where you can, for under $1,500, under $1,000, you can get a will, living will, powers of attorney for you and your spouse, and avoid the LegalZoom rocket lawyers of the world, and only spend a little bit extra money. So if anybody has any questions, you can always reach me through my website or by emailing me. So back to the probate process. So you get appointed as the executor, and there really is no closing process. Just once you get the inheritance tax forms filed and you get an inheritance tax waiver and you can sell the properties that need to be sold and the final income tax returns are done, that process will basically be finished. Depending on the way the will's drafted, you might be able to take an executor fee. If you are the sole beneficiary of the estate, you probably don't want to take an executor fee because you're creating taxable income for yourself. But you can get some advice from financial advisors and from attorneys on that. So a difficult subject, but I think an important subject that I've been getting questions about because people are losing loved ones during this whole crisis at a higher rate than they probably would do so without it. So I think it's something you need to know. If you can always do research, if you have questions, email me, I'm available. And until next time, the next update will be following Tuesday at 10:30, and hopefully we'll be live on Facebook. At that point, Facebook won't have any issues. Thanks for listening.